Good morning, and welcome to the February 2022 oral arguments for the Kansas Court of Appeals. My name is Sarah Warner, and I am the presiding judge for today's proceedings. Before I call this morning's first case, I would like to take a couple of minutes to introduce our distinguished panel of judges. First, Judge Amy Klein, who is a member of our court, is joining us from Wichita today. And we're also fortunate to have Judge Rachel Pickering in Topeka serving by appointment today. Judge Pickering serves as a district court judge in Shawnee County and, of course, was an experienced appellate attorney before joining the bench. In preparation for today's argument, we judges have thoroughly reviewed the briefs that you have submitted as well as the court record, along with a legal memorandum that has been prepared by a research attorney. That means that we are thoroughly familiar with the facts of the case, but because this argument is streaming online and will be archived as a standalone video, I have asked counsel for the appellant to provide a 1-minute factual summary as to how we got here and what the issues are before us before diving into the argument. This case is scheduled to allow each party 15 minutes of argument. I will be keeping time, including any rebuttal time that is granted to the appellant. So at this point, I will call the first case on today's docket, case number 123395 from Sedgwick County, in the manner of Lene Colleen Williams, appellee, versus Emmett Williams Jr., appellant. Will the parties please state their appearances?
Your Honors, the panel and counsel, the appellant, Emmett Williams Jr., appears by and through his counsel, Christopher J. Vendeska.
Thank you.
May it please the court, Your Honors, the appellee, Lene Williams, appears by and through counsel, Julia Leth Perez.
Mr. Vendeska, would you like to reserve any time for rebuttal?
I would like to reserve 4 minutes, Your Honor.
4 minutes are granted. And counsel, you may begin.
Thank you, Your Honor. Just a brief background. The parties were divorced in 2012. They had two minor children. At that time, child support was ordered for Mr. Williams at the amount of $2,000 per month. He actually had a credit on the child support calculation because his parenting time schedule under the child support guidelines entitled him to a monthly credit, which is basically a percentage discount from the standard amount based upon him having additional parenting time. So that parenting time was not only on the weekends, but every other weekend, but also some time overnight during the week. Basically, the crux of this appeal is that in 2018, Mr. Williams, I'll just refer to him as Emmett, he's the appellant, filed a motion to modify child support. He had previously had a position during 2015 and 2016 and part of 2017 where he earned substantially more. He was not aware of any duty to notify the other party of the increased income. Nevertheless, in 2017, the income with his position he took decreased, and it decreased significantly. So he left that job and found a different position as a surgical technician, and then later filed a motion to modify child support. He filed the motion to modify child support about 6 months after he left the prior position. In response to the motion that he filed, the mother, Lene, requested documentation of his income. He provided that, and basically then the parties ended up going to court and reaching an agreement rather than having any type of court hearing. The agreement provided that all past child support was neither party owed either for any past child support. And what Mr. Williams understood is that that was kind of a global resolution of past child support. As part of the agreement, he agreed to pay additional amounts valued at about $13,000 or $14,000 above what he would owe as child support based upon his new income. And there were other things discussed and agreed upon. The mother, Judge Rundle, a judge in Sedgwick County, approved the agreement in August of 2018. Later, about 6 months later, the mother with the new attorney filed a motion asking to go back and request sanctions, which is something that exists under the Kansas Child Support Guidelines for a failure to disclose a material change of income. Basically, what the issues that we have for this appeal are the parties reached an agreement. We consider that to be a valid and binding agreement. There was consideration exchanged, and the mother negotiated and accepted the consideration. She should be precluded from coming back and relitigating any issues related to child support owed prior to June of 2018, which is basically the time frame in the agreement. The agreement that
Counsel, I have a quick question for you. In this agreement that you had, did you ever define what child support means?
Your Honor, the paragraph 16, well, if you're asking if there was a specific reference that specifically defines child support, I would say, I guess the answer is no, there wasn't. Regarding my clients or our understanding, Mr. Emmett had counsel, Lene had counsel. As I mentioned, Mr. Williams paid additional amounts above what he would owe under the child support calculation that was updated. But paragraph 16, the language we agreed upon in the order was the parties agree that the terms of this agreed order regarding child support fully resolve any and all amounts owed by either party to the other party for child support through June 26, 2018.
Counsel, would you agree that generally speaking, a court can't retroactively modify a child support obligation?
Yes, Your Honor. I think that, but the crux of
so if that is the case, then isn't it true that in July of 2018, if Emmett was paid up to that point, then he didn't owe anything on a child support obligation, but that doesn't change whether he violated his duty to disclose. Do you see the difference?
I see a difference, Your Honor, but I think there's still a distinction to be made. There is a duty to disclose. Mr. William Emmett's position was he wasn't aware of that duty, and nevertheless, he didn't disclose those changes of income. He did disclose those prior to reaching this agreement.
And just from my review of the records and the hearing transcripts, it looks like the first time that income from 2015 through 2018 was disclosed to Lene Williams was in May of 2018. Is that right?
You're correct, Your Honor.
And when was the first time that income change was disclosed to the court?
When was it disclosed to the court?
Yes.
Your Honor, I would say that the income was provided to the subsequent income information was provided to the subsequent judge by counsel, including this counsel at the time of the hearing before Judge Kirby.
And that was in April of 2019?
That would have been in April of 2019.
Okay, thank you.
Judge, but again, and please, any panel member, feel free to interrupt me, but we maintain our position, Your Honor, that there can only be a sanction for a past amount owed, and this is without distinction as to what you call it. I understand the district court distinguished that sanction is not past child support.
And I just want to try to figure out exactly what you mean by that, counsel, because if we cannot retroactively modify a child support order, and yet a person hasn't disclosed a marked change of income for more than 4 years, what is a court to do in that circumstance?
Judge, I think the court, in the circumstance where the parties have reached an agreement and there's additional consideration paid by one party to the other, which exceeds the amount that he would owe under an updated child support calculation, appreciate the court, I would suggest, should appreciate that there was an agreement and there was different things taken into consideration. Again, the premise on our position is there can't be, if a party who owes child support has fully satisfied any obligation to the other party, then basically there can't be a basis for a sanction. I understand the court can look at, well, the premise behind the language in the child support guidelines is that if there would have been a disclosure, the child support would have been modified. Therefore, there is an additional amount that would have been owed. Basically, the way you calculate a sanction is by calculating child support. These provisions are found within the child support guidelines and only exist on that basis. So the premise
as part of that agreement, had the parties agreed? It seems like there was some unresolved question that remained with regard to the effect of this change in income,
Sure.
in particular that whether that change could be imputed into the future income. Is that accurate?
Yes, Your Honor, and I appreciate you bringing that up. Again, I'm happy to address these questions. I think it actually benefited Emmett that there was a exchange on the record before Judge Rundle for approval of the order, because at that point in time, it was made clear on the record that there was only one issue that was reserved by this agreement. That issue was the possible future imputation of income to Emmett, basically imputation meaning artificially attributing to him a higher income that he previously had. That issue was reserved so that when child support was reviewed in January, the court could potentially utilize a prior income for the income attributed to Mr. Williams. As far as the other, that Ms. Lene was present at the hearing before Judge Rundle. She had counsel at the hearing, the same counsel that negotiated the agreement. The Judge Rundle specifically somewhat pressed the parties, particularly Mr. Robinson and Lene's counsel, as to any other issues that were not deemed resolved by virtue of this order. So our position is that that this is an issue, basically, that is part of a motion to modify that covers a past period of time. And because my client, and he understood that this was a resolution, that there were no other amounts owed to Ms. Williams. And that's why he agreed to pay almost $14,000 of additional amounts. Those weren't just gratis, those were additional amounts.
Counsel, since you represented Mr. Williams at that time, could you talk to me a little bit about, or talk to the panel a little bit about how that agreement came about? There were some references in the record to a mediation. Did this agreement come out of the mediation, or was that for something else?
There may have been a mediation related to custody and parenting time, but as it relates to basically this agreement, Mr. Williams' motion was filed in April. The mother almost immediately filed a motion regarding parenting time, then issued discovery. We provided thorough records regarding the incomes in May. We met in June on the date the matter was scheduled for hearing at the Sedgwick County Courthouse. The counsel and parties met and basically went back and forth and hammered out terms of an agreement, which were reduced to writing on a notepad that actually I maintained. I drafted the order and sent it to counsel, and basically Mr. Robinson requested a few minor changes. Basically, one of those was that the child support issue could be reviewed in January of 2019, which was later, that was synthesized or determined by Judge Rundle to mean that the issue of whether future child support calculations could utilize the past income. So our understanding at the time was that this agreement was a global agreement that resolved past issues relating to child support, including sanctions. Otherwise, Mr. Williams wouldn't have agreed to pay amounts that he wouldn't owe based upon his current income, actual income at that time. And that the only other issue that was left remaining by virtue of this agreement was a future issue. So,
and is there any reference in any of these documents before the February 2019 motion by your opposing counsel? Is there any reference to sanctions whatsoever?
Is there any specific reference?
Yes.
Not that I'm aware of, Your Honor, but I think still, even under the argument of res judicata, it's an issue that could have been raised at the time and would have been timely to have been raised at the time that the parties reached the agreement. I mean, based upon res judicata, it was the same parties, the same claim, something related to child support.
But it's an ongoing case, right, counsel? This is an ongoing case, and a district court can always revisit its orders in an ongoing case.
Judge, there's authority in the Hill case, which is cited in my brief, that there are judgments concerning custody, child support, and education are considered final judgments. The court does retain, you're correct, the court does retain jurisdiction over these issues while a child is a minor. But to that end, once there's a judgment, basically it's considered a final judgment. And so res judicata, our position is res judicata does apply. And that basically, even if the court did not, and so the district court, Judge, our position, our panel, our position is that when the district court first ruled, it was clear and she understood, recognized that there was only one issue reserved, and that one issue being the future imputation of income. She incorrectly or basically misstated the facts in ruling, granting a sanction in her first order based upon the misunderstanding that there had been, that Lene did not have in her possession, she had not been apprised of that past income at the time that the agreement was reached. In fact, she had. And that was, again, part of the discourse that was in the exchange as far as what of value was Mr. Williams going to provide in exchange for concessions on behalf of Miss Williams. When the
counsel, we are coming close to the end of your time, and I know that I've been dominating it with questions, so I want to make sure that any of the other panel members, if they have questions, have time to ask those. Do any of my other panel members have questions?
Not at this time, thank you.
Counsel, can you tell me how much time passed between the time that Lene learned of the failure to disclose the increase in income and the time the agreement was reached between the parties?
I believe approximately 30 days. I think I could review the record, but the discovery responses, I believe, were provided around May 25th of 2018. And the parties met in person at the court in court at Sedgwick County at the courthouse on June 26th of 2018.
Okay, thank you.
Counsel, if you'd like to take a minute and wrap up, and then of course you have your rebuttal time that you have reserved.
Thank you, Your Honor. Again, just to restate, our position is that there was a valid binding agreement, that there was consideration exchange. Kansas courts encourage people to reach agreements. I don't believe there was an ambiguity, even if one could say that there was an ambiguity, that the doctrine of res judicata still applies based upon the circumstances of the case. The other issues relate to if the court doesn't determine that the appeal fails on that basis, the court erred in utilizing the extended income formula, which is it's a discretionary. The child support guidelines contain the presumptive child support amount, which basically is what's contained in the tables. In the event that the district court decides or elects to diverge from that and basically use their discretion and set child support based upon the extended income formula, it being in a discretionary act, there has to be some type of factual basis to support the court's decision. Factual basis that wasn't provided in this instance. Mr. Williams had no advanced knowledge that the extended income formula was even something that was being requested or considered. Ultimately, then the district court utilized the extended income formula and under section BB2, and I appreciate that the panel has reviewed everything. That saves a lot of time going through explaining the child support guidelines. But under BB2, the court can sanction a party for the value of what would have been paid in child support if the income material income change would have been disclosed. And then the court—
Counsel, I think that we are at the end of your minutes, and I've allowed you to run over, but you do have 4 minutes reserved for rebuttal.
Thank you.
Thank you. Counsel?
Your Honors, the issue before the court is very clear. It's whether or not the judge abused her discretion in awarding a sanction for Emmett's failure to report his increase in income. As to the first issue brought forward by counsel, whether or not this agreed order is a final order having a global resolution, well, Your Honor, the district court reviewed the agreed order and found that when you read together paragraphs 8 and 16, it creates an ambiguity. A final order does not reserve a review date. A review date is an ongoing process. Your Honor, also, as it was noted by the Court of Appeals, there was no definition of what child support was. There was no included waiver of any sanctions. My client learned of this increase in income 30 days prior to this hearing, Your Honor.
Counsel, given that your client, I mean, it's not much time, but your client had this information for a month. Why is it that this wasn't brought up until almost 8 months later?
Your Honor, after the hearing in front of Judge Rundle, additional discovery needed to be done because we learned that Emmett had intentionally failed to disclose his income. He'd gone from earning $109,692 at the time of divorce to 2015. His taxes reported $358,737.
Counsel, I understand that was a huge difference, but your client was aware of that difference in May of 2018. So my question is, why the delay, and why wasn't this brought up at the hearing in July and then the hearing in August of 2018?
Your Honor, because my client needed to do additional discovery, not just to rely on the income tax statements.
Why wasn't there a request to the court to say, we're not ready to resolve this child support issue? We still have these questions that remain regarding these increases in income.
Well, Your Honor, I would put forth to the court that the issue of child support is a completely separate issue than the issue of sanctions. There's different laws that apply. The statute applies differently to how they're looked at and calculated. My client agreed to a partial resolution to be set for review. And in that time, between the partial resolution and the review, then the additional discovery was done to bring the issue of sanctions before the court.
And what additional information was learned after the August 2018 hearing?
I did a business record subpoena to Emmett's employer to verify his contract, to verify his earnable wages. Emmett's deposition was taken to learn about the additional properties that were not disclosed that he had acquired, he had sold, he had rental properties. Additional discovery was done in the form of interrogatories, requests for production of documents.
And is there a reason that couldn't have been done before that order was entered?
Your Honor, at the time that order was entered, at that court date, 30 days would not have been enough time to do business record subpoenas, depositions, and to obtain all of that information. When we filed our first business record subpoena for his employer, opposing party objected to the business record subpoena, then later came back and signed an agreed waiver to get the business record subpoena. Your Honor, the things disclosed in the deposition showed that Emmett had paid off his house that he lived in, that he bought himself a new Cadillac. That
Counsel, I understand that you learned information and that you were able to gain that information. My question was a little bit different though. And it was, why couldn't those actions, those discovery steps have been taken before this agreed order was entered?
Your Honor,
meaning what was the rush to get the agreed order entered and say that the child support issue had essentially been resolved with the exception of the imputed income question when all of these questions remained?
Your Honor, I did not represent Lene at that time, but I will state from reviewing the transcript and the record, and my client's belief at the time was that the only child support issue that order dealt with was what would his current support amount be set at, and it was just that issue. It did not address what child support would be If he was imputed, it did not address whether or not there would be sanctions for his unreported income. It was a very narrow and limited resolution of their motion to modify child support at that time based off of his reduction in income.
Okay, counsel, I have to stop you there. And I know your opposing counsel is going to be pointing, just to respond to that. You sound like it was less than what it actually is what I'm taking it. Part 16, the parties agree that the terms of this agreed order regarding child support, quote, fully resolve any and all amounts owed by either party as to the other for child support through June 26, 2018. And yet the client signed this, and yet there was still discovery to be done. Is that correct?
Your Honor, there is ongoing discovery for the issue of whether or not there would be sanctions and to try to determine what his actual income was. So it would not be based just off of what he's claiming it is for income tax purposes. Also,
I don't think anybody is saying that your client had to accept Emmett's word, but I think what at least I'm struggling with, and perhaps the rest of the panel is struggling with, is she reserved the future imputation issue at the agreed order, or at the hearing when they signed the agreed order and reached the agreement. Couldn't she just have easily reserved the issue of the failure to disclose the income and say, look, I need to flesh some things out on this issue as well? I mean, why couldn't both issues have been resolved or reserved at that time?
The issue as to the sanctions, Your Honor, this is an ongoing pending case. It is not a final order, a final case. And so for my client to bring the issue of sanctions at a later date is not barred by statute. It's not the same claim. It's not barred by res judicata. Your Honor, the change in income actually wasn't reported to the court itself until April 2019. So even at this hearing with Judge reviewing the agreed order on the record with the parties, the court itself did not even have knowledge of this change in income.
But your client did, right? And your client's attorney had it for at least 30 days. They could have brought it to the court's attention and said, oh, by the way, we also want to reserve this issue because we've got some ongoing discovery on it, couldn't they?
Your Honor, the issue of sanctions was not before the court on that date. The issue of sanctions was one that was still pending with the issue for review for the court to determine whether or not Emmett should be sanctioned for not reporting his previous income.
Counsel, I've reviewed the record, and it looks to me, and feel free to correct me if this is incorrect, but it looks to me that the first time sanctions were ever mentioned was in the motion that you filed in February of 2019. Is that accurate?
That is accurate.
So when you say that sanctions were very much being litigated in July of 2018, I mean, what do you mean by that?
That at the time his income had been disclosed and that hearing was held, 30 days with his income taxes being given, notified that there might be an issue for sanctions, but that further discovery was needed, and that's the motion I filed in this case asking the court to set sanctions.
So was that the first time that Mr. Williams was alerted to the fact that you were seeking or even thinking about sanctions?
Your Honor, that would be the first court filing where Mr. Williams would have noticed that we would be seeking sanctions, Your Honor. Mr. Williams at all times has been represented by counsel, and so I do believe that he would know, or his counsel would know, that under the child support guidelines, sanctions for unreported income, undisclosed income is sanctionable, and those sanctions can be brought.
But you hadn't indicated to Mr. Williams or his counsel before that time that you were seeking sanctions, had you?
Your Honor, when I entered it on the case, it was indicated to opposing counsel and Mr. Williams in the fact that I filed a motion asking for sanctions.
Okay, I think I understand. Thank you.
Counsel, your opposing counsel has mentioned that in negotiating the agreement, that Emmett perhaps wouldn't have agreed to pay an additional $14,000 if he had known your client was seeking sanctions. What's your response to that position?
Your Honor, I find it interesting that he would not have paid in the $14,000 when the sanctions, if it were to be just what he should have paid, would have been $23,126. So Emmett, in paying in that money, actually paid less than what he would have paid just based off of what the first level of sanctioning is under the guidelines. Also, my client would not have entered into an agreement to waive the additional amounts owed to her, especially after finding out that he had undisclosed income for all of these years. In addition to that, it was put before the court. My client had their son 100% custody for an entire year, been paying all of his living expenses, all of his costs. Emmett had been paying child support. My client had been bearing an additional burden financially. And so for Emmett to claim that, oh, my client was willing to waive any sanctions because he was willing to pay $14,000 in child support flies in the face of it saved him almost $10,000, and that's just off of the first sanction. Off of the second sanction, it saves him almost $40,000, Your Honor. And so, yeah, Emmett did pay that amount in, but when you look at the fact that Emmett had $1 million increase in income over a 2-year contract that went unreported, not only did he have the benefit of that income, now they're trying to argue that he shouldn't be sanctioned because he agreed to pay above the amount of child support for a period of time. The whole purpose of the child support guidelines is to keep people from failing to report. And what Judge Kirby did in this case, she did not abuse her discretion, is not an error of law. What Judge Kirby did is she went in and appropriately awarded sanctions in the amount of the $23,126.40 for the first sanction, and then the additional sanction, which totaled his sanctionable amount to be $70,000, approximately $72. And I'll have the court note, Judge Kirby adopted Emmett's child support sanctions, not Lene's. The sanction amount was adopted from what Mr. Vindiska argued before the court. The court gave him the 10% reduction for his parenting time. The court gave him the reduction for the amount that he'd overpaid. The court only granted attorney's fees on the last motion to reconsider. So for all the other work that I did and her attorney before me did in this case, those were not given as sanctions. And when you look at a person who's made $1 million in 2 years, doesn't report it, doesn't want parenting time with his son, is saying that paying $14,000 should get him out of having to pay what he would have had to pay, and that the judge shouldn't penalize him with another sanction, flies in the face of the law. Him even paying what he should have paid under the child support guidelines just puts him in the position he would have been in had he disclosed. That's not a penalty. That's not something that's going to keep him or others from going forward and not providing updates on income increases. The court did not calculate child support. The court calculated a sanction, and the other sanction's appropriate because the other sanction says if you make $1 million in 2 years under a contract and you don't report it, we need to look at that seriously and not just look at what you should have paid as the bare minimum, but what is going to teach you and what is going to set the law to say you need to report your income. A sanction is intended to punish a person or to encourage a person or other persons going forward to follow the law. Judge Kirby did not abuse her discretion She did follow the law. This is a sanction. It's not child support. And the issue of a sanction was properly before the court after our motion was filed, after additional discovery was done, after we provided the court with the parts of the transcript from Emmett, provided the court with
Counsel, we're coming to the end of your time. And so I want to make sure that if any of my colleagues have any questions, that they're able to ask those. So panel, do we have any additional questions for counsel?
I do not.
Counsel, that the additional $13,000 to $14,000 that your opposing counsel said this client paid, what was that for?
That payment was for an agreement that his child support obligation was paid current by agreement. Child support, though, not sanctions. It was not an agreement for sanctions. If it was in the agreed order, it would say Emmett agrees to pay $14,000 in additional child support in lieu of sanctions, or Emmett agrees to pay a $14,000 sanction for not reporting his income. So that was in an agreement to get his child support brought current to satisfy that obligation. But in no ways is that Emmett agreeing to or my client agreeing to a sanction or waiver of my client's right to bring that sanction.
Counsel, you can, if there are no other questions from the panel, take a minute and wrap up, and then, well, thank you for your submission.
The issue of child support sanctions was still a pending issue. This order was not a final order. It was an order set with a review date. At the review date, Judge Kirby heard the arguments of counsel, saw the exhibits of counsel, and correctly ordered sanctions for Emmett's failure to pay his child support obligation, failure to report it. Not only that, the court has now, the district court has heard this issue argued, I believe, 3 times and gone back every time and found he did not disclose. This is not a final agreed order, and sanctions are appropriate. And the court was within its discretion to award the amount of sanctions the court awarded to prohibit or discourage Emmett or others from failing to disclose their income so they can keep a gain and a windfall at the loss of their child. Because at the end of the day, that's exactly what child support's about, is support for the child. And that's what the sanction is about. The sanction is about support he didn't pay, support he didn't disclose, and support that would have gone to and still should and could go to his children or his child who's still under the age of 18. Thank you, Your Honors.
Thank you. Mr. Vendeska, you have 4 minutes for rebuttal.
Okay, Your Honor, thank you. I appreciate it. Judge, I would just first note, and I think clarify, the issue of sanctions, and one of the panel members, I think, pointed this out. Ms. Lethbres says, well, there was a review hearing and the court addressed this and that. The issue of sanctions was not set for review. Possible imputation of income for future child support calculations was set for review. There is a duty to report a change of income to under BB2 of the guidelines. That duty is owed to the other parent. That duty is not owed to the court. I understand there's some questions about when the court became aware of it. The duty is owed to a parent. And sanctions are discretionary. BB2 says the court may order sanctions. It's not a one-size-fits-all remedy in every case. So in this case, our position is the duty was owed to the mother. Basically, she negotiated an agreement that precluded the court from having a basis to award the discretionary sanctions. I think if it's not discretionary, it becomes more clear that there's something that probably needs to be specifically addressed in the agreed order. As far as
one quick clarification, the amount that your client paid in excess of what he's saying was owed under child support guidelines, does that include the amounts that he paid before he sought a modification?
I don't believe so, Your Honor. What it includes, and I can specify that. I don't want to use up my time necessarily because I had a couple more points to make, but he would have.
Well, it would be helpful for our discussion, I think. So if you could answer my question, that would be great.
Sure. Okay. So basically, based upon when the motion was filed in April, the modification under the Kansas law would have been effective May 1st, or could have been effective May 1st, the reduction from 2,000. He agreed to pay 4 additional months of $2,000. So he received a credit of $882 for 2 months and $1,012 for 2 months. Add those up, you'll get $4,000. In addition, though, under the divorce decree, he was entitled to claim one of the children for taxes every year. He agreed to allow Lene to claim both children, which, depending on how her taxes were filed, the minimum in 2018 that would have been is $2,000. Likely, there may have been a greater benefit. Also, there was a $7,841 duplicate child support payment that Mr. Williams had paid, basically contemporaneous with this motion being filed, because the court trustee in error stated there was an arrearage, which ended up later they clarified it wasn't. So I totaled those up to equal $13,841.60.
Thank you. That's very helpful.
Thank you, Judge. And as far as the Judge Kirby ruling 3 times against my client, her basis for the ruling changed each time. Initially, she said there was no ambiguity in the agreed order, that it was clear that the party's intent was only to reserve the issue of future impossible imputation of income. I want to address the discovery. We'll list a couple of things. It sounds like a big deal to say Mr. Williams was earning $1 million a year. He wasn't. His income did materially change, but he wasn't earning $1 million. We're not disputing that his income materially changed and that basically he didn't provide timely disclosure. There is no dispute here. But as far as saying it's $1 million a year and there was a significant windfall, that's not a correct statement. Likewise, as far as his son, he was petitioning the court to have counseling with his son because he was trying to have contact. And that's one of the disputed issues basically we're going to court for. So as far as the allegation that the additional discovery needed to be issued, I dispute that as well. Basically, there was additional discovery, there was additional discovery issued. I initially objected. Basically, the objection was based upon my understanding that the only reserved issue was imputation of income. Once it was clear to me that what was being sought only related to imputing income, I withdrew the objection. Your Honor, just to be clear, and it's in the record, we provided in May of 2018 129 pages of discovery responses, and those were tax documents, those were pay records, those were contracts. There was nothing left to be discovered as far as the actual amounts that were earned. The issue in the additional discovery, as I understood, based upon the questions we received and also the deposition questions were, is there a basis to artificially attribute going forward the prior income to Mr. Williams under the premise that he was intentionally underemployed? And frankly, the district court, Judge Kirby, that argument was made to her. She denied that. She determined that he wasn't intentionally underemployed or intentionally unemployed, and that there was not a basis to impute his prior income.
Counsel, I've allowed you to go over a little bit in light of my lengthy question, but I'd like you to wrap up in about 30 seconds.
Thank you. Your Honor, just to be clear, we proposed child support amounts to the court once the court had ruled against us, I believe the second or third time, because we needed to perfect the issue for appeal. We couldn't appeal and it wasn't a final judgment until the amounts were determined. What the court determined is that basically the sanction for the initial sanction under VB2 against Mr. Williams was in the amount of $7,454. So basically, using the presumptive amount of child support before extrapolating, he was only $7,454 short for all of these years from what he would have paid. Based on how I had counseled my client, and one of the reasons why we reached an agreement, which I assumed was something the other side looked at as well, when you reach an agreement in June of 2018, we thought we were saving all of the attorney's fees, which to a great degree both sides would have to bear, and they have had to bear. Also, when there's an agreement reached there's certainty of an outcome. And basically, frankly, it also encourages harmony rather than disharmony for parties in family court who are continuing to litigate. The initial
Council, we're out of time, so I'd like you to finish, and then we will conclude today's argument.
Okay, Judge, it's an abuse of discretion for the court, first of all, not to recognize that there was an agreement, but second of all, and as importantly, the first sanction was $74.54. The second sanction, which was as considered an other sanction under the guidelines, was the amount of $57,283.20, almost 8 times the amount of the additional sanction. The court ordered that basically as a deterrence or a punishment for failing to disclose, not based upon the dollar value of what the child support would have been if Mr. Williams would have made the disclosure. Our position.
Council, I'm sorry to stop you, but we are out of time today. But we appreciate the attorney's arguments and thank you. We will take this matter under advisement, and we will get out a written decision just as soon as we can. At this point, we're going to be briefly in recess, and we will